Most American workers have far more legal protections than they realize, and far fewer than workers in many other countries. The United States operates primarily under at-will employment, meaning your employer can fire you for any reason, no reason, or even a bad reason, as long as it is not an illegal reason. That last clause is where it gets interesting because there is an increasingly long list of illegal reasons your employer cannot use. Understanding the difference between things your boss can legally do, even if they are unfair and infuriating, versus things that cross into illegal territory is essential knowledge for every worker in America. This is legal education, not legal advice. Consult a licensed attorney for guidance on your specific situation. The Fair Labor Standards Act, enacted in 1938, is the bedrock federal labor law. It sets the federal minimum wage, currently $7.25 per hour, though many states and cities have higher minimums, and mandates overtime pay at 1.5 times your regular rate for every hour over 40 in a workweek for covered non-exempt employees. Exempt employees, generally those in executive, administrative, or professional roles earning above a salary threshold, do not receive overtime protections. Misclassification of workers as exempt or as independent contractors when they should be employees is a major compliance problem. If you are being denied overtime that you think you are owed, that is a potentially serious wage violation with significant remedies. Title VII of the Civil Rights Act of 1964 prohibits employers with 15 or more employees from discriminating based on race, color, religion, sex, or national origin in any aspect of employment: hiring, firing, pay, assignments, promotions. The Supreme Court in Bostock v. Clayton County in 2020 extended Title VII's sex discrimination protection to gay and transgender employees in a landmark 6-3 ruling. The Age Discrimination in Employment Act protects workers 40 and older from age-based discrimination. The Americans with Disabilities Act requires employers to make reasonable accommodations for qualified employees with disabilities. The Equal Pay Act requires equal pay for equal work regardless of sex. These laws collectively create a substantial framework of anti-discrimination protections. The Family and Medical Leave Act gives eligible employees at companies with 50 or more employees the right to take up to 12 weeks of unpaid, job-protected leave per year for certain family and medical reasons, including the birth or adoption of a child, caring for a seriously ill family member, or your own serious health condition. The key word is unpaid. FMLA does not require paid leave, though some state laws do provide paid leave. Your employer cannot fire you, demote you, or otherwise retaliate for taking FMLA leave. Pregnancy discrimination is also separately prohibited under the Pregnancy Discrimination Act of 1978, which requires employers to treat pregnant employees the same as similarly limited non-pregnant employees. Non-compete agreements are a complicated and rapidly evolving area. These clauses prohibit employees from working for competitors for a period of time after leaving a job. Their enforceability varies enormously by state. California bans non-competes almost entirely, treating them as void as a matter of public policy. Other states like Florida enforce them relatively aggressively. Most states require non-competes to be reasonable in scope, geographic area, and duration to be enforceable. The Federal Trade Commission proposed a nationwide rule in 2024 to ban most non-competes, though litigation over that rule was ongoing. Whistleblower protections exist under dozens of federal statutes, protecting employees who report certain illegal activity from retaliation. Here are the most important employment rights in practical terms. Your employer cannot fire you based on race, sex, religion, national origin, age over 40, or disability. You are entitled to overtime if you are non-exempt and work over 40 hours per week. You can take FMLA leave without losing your job at qualifying companies. You can report illegal workplace conduct without retaliation under various whistleblower statutes. But at-will employment means your employer can fire you for almost anything else, including personality conflicts, downsizing, and even arbitrary reasons. Document workplace problems in writing, keep copies of any retaliation evidence, and consult an employment attorney if you believe your legal rights have been violated. Many employment attorneys work on contingency for discrimination claims. This is legal education, not legal advice for your specific situation.